A judge gives a defendant a second chance with community control after a domestic violence case, warning that family responsibilities are not an excuse for breaking the law. Months later, new allegations of domestic violence emerge, leading to a probation violation hearing and a dramatic courtroom decision.
The comment that I have for you, Mr. Anderson, is I understand you have a young daughter and you want to be there for her. You want to support her in any way you can. Just keep in mind that if you come back before me and you have violated one of my orders or you otherwise break the law, you will not be able to use her as an excuse. You are on notice. You know you have a daughter. You know you need to be there for her. So I'm not going to listen and say, well, Judge, you can't send me to jail or prison because I got this daughter. Well, you better think about that now, because moving forward, you can't simply throw that up in my face and say, well, I have a daughter. No, it doesn't work that way. You're on notice. I'm aware you have a daughter. I'm aware you're trying to get your families to stick together. But if you're going to resort to violence or you otherwise break the law, just keep in mind that will not be an excuse.
Judge, on behalf of the state, my understanding is that Mr. Anderson has 3 days jail time credit. We've received a recommendation from probation. I will defer to probation on this, but I do want to put on the record I have a lot of concerns about this case. The underlying facts are very concerning. I would ask that should the court place him on community control, that a very tight leash be kept on him, and that he be ordered into the appropriate treatment and make sure that he engages, because I do have concerns about the victim's safety in this matter. I don't know, is she here? She wants to make a statement? Okay, so apparently Ms. Thompson is here and would like to address the court.
Brandy Anderson, also known as Thompson. I do ask the court to please allow for probation. We have been together living in the same household, and our very beautiful little girl back here with no concern. I do not have concerns about my safety or the safety of our daughter. I just ask that you please allow him to be able to be on probation, to be able to provide for his family and to help take care of his daughter and raise her. Thank you.
Ms. Tranter, is there anything else?
Nothing further, Your Honor.
Anything from probation?
Nothing further, Your Honor.
All right. Mr. Brewer?
Judge, as you're aware, I find random in support of sentencing, and we are asking for community control. Only to touch on a little bit, I think Ms. Anderson just touched on it, but Mr. Anderson does have a full-time job. He has maintained full-time employment throughout this entire process. He does provide the health insurance for their newborn. Through this process, when the protection order was released back in November or so, they lived together for this long, and it's not to say they never had any arguments, but none of them have been violent. They've gone through counseling. He's helped take Brandy to her doctor's appointments. He was there for the birth of the baby, so they've been together. They've been through a lot. There were a lot of stressors back in during the summer, and that came to a head. But I think they've sought counseling between them, and they're doing what they can to resolve those particular issues, and we're just asking that you consider him for community control.
Mr. Anderson, is there anything you'd like to say?
I'd just like to say I'm really sorry that any of this ever happened. I've never had a history of violence at all. Me and my wife, we just got married, found out that we weren't married, found out that she was pregnant, so we had to get married again to make it legal. We moved into a new house. We were just under a lot of stress. We got into an argument. I should have just walked out the door. We both did things I'm not happy about. I love my daughter. I've made a lot of changes in my life to get where I'm at today. If you talked to me 10 years ago, I'm so much better than what I used to be. If you give me a chance, you won't see me again.
All right, the court has considered the statements made here today, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. The court has reviewed the pre-sentence investigation together with the memorandum, sentencing memorandum filed on behalf of the defendant by Mr. Brewer and the attachments thereto. Mr. Anderson, I am going to find today that you're amenable to community control, so I'm going to place you into community control for a period of 3 years. You will be subject to the supervision of the Warren County Probation Department in ordering you to refrain from use of any drugs, alcohol, or marijuana. Do you understand?
Yes, sir.
You're ordered to successfully complete mental health counseling. You will complete the Batter's Intervention Program, and you will complete the Thinking for a Change course. It looks like you have 3 days jail time credit. The court finds that you have the present and future ability to pay the cost of prosecution. So although I'm not going to fine you, I will assess the court costs against you. If you don't pay those, I can't order you to do community service of up to 40 hours per month until you pay that in full, or you make appropriate arrangements to get those costs paid off. The comment that I have for you, Mr. Anderson, is I understand you have a young daughter and you want to be there for her. You want to support her in any way you can. Just keep in mind that if you come back before me and you have violated one of my orders or you otherwise break the law, you will not be able to use her as an excuse. You are on notice. You know you have a daughter. You know you need to be there for her. So I'm not going to listen to, well, Judge, you can't send me to jail or prison because I got this daughter. Well, you better think about that now, because moving forward, you can't simply throw that up in my face and say, well, I have a daughter. No, it doesn't work that way. You're on notice. I'm aware you have a daughter. I'm aware you're trying to get your families to stick together. But if you're going to resort to violence or you otherwise break the law, just keep in mind that will not be an excuse for you. Do you understand me?
Yes, Your Honor.
You're also subject to a discretionary period of post-release control, which means if you are sent to prison on these charges when you are released, the adult parole authority may supervise you for up to 2 years. If you violate those rules of supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year, or the period that you have left on PRC, whichever is longer, that time would run consecutive additional prison time that you get sentenced to. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, that can all be provided to you at no cost. There is no contact order issued at the request of the victim in the case. Is that correct, Ms. Tranter?
Yes, Your Honor.
Ms. Tranter, is there anything else?
Nothing further.
Mr. Brewer?
Yes, sir. Thank you,
All
Your
right.
Honor.
Good luck to you.
Thank you, Your Honor.
42912. Mr. Anderson, there's been a allegation you have violated your terms and conditions of community control. Can I please have a reading from the probation department?
General condition number 1, on May 24th, 26, the defendant committed the offense of domestic violence F3 and was charged in Lebanon Municipal Court, reference case number CRA 2600270.
Sir, did you hear those allegations as they were read out loud?
Yes, I did, Your Honor. They are allegations.
And at this point, the court finds that there's probable cause that you have violated your terms and conditions of community control, so we'll set this over in front of Judge Teep. Do you have the means or ability to retain counsel, or do you need a court-appointed attorney?
I have a lawyer. Yes, I do.
Who is your attorney?
David Brewer.
Okay. Was he appointed or retained?
I paid for him.
Okay, and you retained him for this PV as well? Perfect.
All
We,
of it.
we will get this set with Mr. Brewer. While this is pending, anything from the state with regards to bail?
We would ask that he be held at this time pending a hearing in front of Judge Teep. I'm not sure what his bond is in the lower court. He has a $100,000 bond with EMHA in the lower court. This is a relative, he has not been on probation that long. We would ask that he be held.
Mr. Anderson, anything you would like me to know with regards to bail only, keeping in mind you have the case pending, so you don't want to go into the
Yes.
facts or anything?
So I have been in excellent stance with all probation throughout pretrial. When I was on house arrest, all the things, made it to every appointment, passed every drug test. All I'm asking is that with these allegations, I'm going to take this to trial. If I could get out on bail, go back on house arrest, I have a house I can go to that's nowhere near this alleged victim. I'm in the process of getting a divorce also. I filed. I think she's just upset, a couple of other things, but I'm willing to post bail and abide by everything needed.
I'm trying to look right now. I'm not aware of whether he's posted bond in that lower court yet.
Well, I was told I had a holder, so I didn't put any money down because I didn't want to lose the cash.
If the court is inclined to release him, we don't believe an OR in this case. I mean, for the protection of the public and his ability to reappear, he certainly has consequences he is facing, potentially.
Like I said, I'm willing to go back on the monitor or whatever. I'm just trying to get back to work and then have my right to go to trial.
Where are you working right now?
Valco Melton, I've been there for almost 5 years. It's a machine shop. I was under Officer Edwards the whole time I was on ankle monitor. Got moved to Conroy, and then got moved to Robert Henry. And every one of them I've passed everything, done everything I needed to do.
There is also a domestic violence CPO pending.
just due to the complexity of having a high-level felony, understanding you're presumed innocent of that, coming through and that being the potential violation of community control, I'm going to let Judge Teep take a look at this, so I will say you're to remain in jail until he can get this matter set. They will set this for a final hearing, which will likely be kicked out until resolution of your other actual F3 case. But that way, Mr. Brewer can get in front of the judge and discuss bond with him. So we will get this set as soon as possible with Mr. Brewer.
Do you know when?
Hopefully next week sometime. That would have to ask Judge Teep to sign the commissioner. Usually they set 1 to 2 weeks, aiming for 1 week, if not less. So,
So there's no bond?
not right now. All right, best of luck to you, sir.
Thank you.
This courtroom documentary follows the case of Mr. Anderson, who receives probation after a domestic violence conviction and promises to change for his family. Despite the judge's warning, new allegations emerge months later, leading to a probation violation hearing and raising serious questions about accountability, rehabilitation, and justice.